There's a slide on contribution and indemnity. Contributing any joint tortfeasor who pays more than his share of the plaintiff's damages may seek contribution. Partial reimbursement from other joint tortfeasors. This right of contribution is not affected by the plaintiff's choice of defendants and may be enforced through a third-party claim, impleading, or separate contribution action if the plaintiff does not join all the tortfeasors. Meaning, a defendant can bring a case against A and B, or he can bring a case against A, and then A is going to have to pay and bring a case against B himself. Indemnity, which entitles a party to full reimbursement of costs of suit, which is available when the defendant is vicariously responsible or liable for another's action, but where the defendant himself was a co-defendant but not necessarily a concurrent tortfeasor. Okay, so the duty of care failure to act is a special section in our book. A duty imposed with regard to risk that arise within the scope of a relationship. A duty may arise based on the degree of knowledge or foresight of the risks. And this is from the Commonwealth v. Peterson case. A duty to rescue. There is no duty to rescue from Ellis, Ayers, and Company v. Hicks. The duty to rescue, a duty to take positive or affirmative steps. However, a duty to rescue may be owed where the defendant controls the instrumentality causing the injury. So, I don't know if this is the case they're referring to, but a boy is on an elevator and gets his finger stuck in the elevator, and the defendant had a duty there to act because he was the only, because he was the party in sole control, exclusive control over the instrumentality causing the injury, which is the operation of the escalator. So, and the boy is an invitee on the defendant's land. This is distinguishable from the case where the trespasser gets stuck between a fence and a rail on someone's property where he is trespassing. The owner of that land cannot possibly be expected to rescue the plaintiff, even if he is like exclusively in control of the instrumentality of like the fence and land where the plaintiff's gotten stuck. Professional's duty of care under this failure to act premise. The duty to exercise reasonable care to protect third persons will subsist once a therapist in fact determines or should have determined that a patient poses a serious danger of violence to those third parties. And there is a duty to protect third parties against serious danger of which one has special knowledge threatened by those for whom one bears a special responsibility. So that is just plainly the best way to put it. There is a duty that could be found under failure to act theory, placing responsibility on the defendant. So there's a duty upon the defendant to protect third parties against serious danger of which he has special knowledge and breach another duty to his client. Negligent infliction of emotional distress, different from intentional infliction of emotional distress. The defendant may be found liable for negligent infliction of emotional distress. See Daly v. LaCroix. Here, court uses the physical manifestation test, replacing the physical impact test. And the plaintiffs are exposed to the risk of physical injury. I have no idea what we're talking about. Bright line test for NIED came from Thing versus Lechusa. Damages for emotional distress are recoverable if and only if the plaintiff establishes a close familial relationship, the plaintiff is present at the scene and aware it is causing injury. This is again is referring to a zone of danger. And the defendant, as a result, suffers serious emotional distress beyond that of disinterested witnesses, and which is not abnormal. So, I'm just going to talk about the cases here. In Daly v. LaCroix, LaCroix ran a car into like a phone pole, and the phone pole's like line struck the Daly house, and Mrs. Daly wasn't home, but there was sort of devastation, and here the court used the Physical Manifestation Act test instead of the physical impact test. So basically, the devastation I'm referring to is for kids. One of them had some psychological, both of them had psychological harm, and we weren't using the physical impact test to say that, okay, one of them lost a limb and one of them lost an eye. We use a physical manifestation test that the emotional harm manifested according to an expert. And I think that's what we're trying to say here in so many words. In the Thing versus Lechusa case, where I suppose was like around the corner from where there was an accident that like killed her son, she can't recover for negligent infliction of emotional distress upon herself from the driver because she wasn't present at the scene or anywhere near the zone of danger. I mean, she was close, but she saw it, but she wasn't a witness to an actual accident. And so she did meet the element of being in a close familial relationship. And she did meet the element of, or one would think she met the element of suffering serious emotional distress beyond that of disinterested witnesses, and which is not abnormal, which isn't just regular grief. But she just didn't really witness it. She came after the fact. So we talked a little bit about failure to act when, say, someone is in exclusive control of the instrumentality of the injury. We're going to talk about the owners of land's duty of care now. And actually, we're talking now about property law, but from, a tort action standpoint. So for the outside of the premises, the landowner must exercise reasonable care under the circumstances by maintaining his or her property. This is in Taylor v. Olson. The balancing factors test include the location, the use of the property, the customary practice, and gauging reasonableness. The breach is determined by notice of the risks in the conduct and the precautions necessary to protect the public. So that's Sullivan v. Wilmington Park is where that case came from, where the fence that was built outside of a ballpark on like 11th Avenue in Wilmington, Delaware, was nowhere near high enough to protect people who were lawfully using the road outside of the fence, and several balls went over the fence, and one struck Salavan, and the owner was liable for a breach because he knew that balls go over the fence like every single time there's a ball game. Okay, next. Duty of care, owners of land prior to on the premises. Types of duties to trespassers. See notes. Unknown trespasser. A landowner does not owe a duty to protect an unknown trespasser. So this is the train track, I guess. Example, except we're talking about on the premises. So, known trespasser. A landowner owes a duty to a known trespasser to use reasonable care to avoid injuring the trespasser through active operations. This is changing to a more flexible approach to determining liability and going to the balancing test. Tolerated intruders. The defendant's continued toleration of a trespasser amounts to permission to use the land, so the plaintiff then becomes the licensee. And dangerous conditions known to the owner is discussed in Note 8. I don't know what note. Okay, Note 8 of the case that I don't have in front of me right now. So I guess we can go back to that since it's a little tricky trying to figure out what the duty is to trespassers by the owner of the land. We do know one thing though, he can't use deadly force to protect his land from trespassers. Duties to invitees and licensees. A licensee is one to whom the license is granted, someone who has official permission to do something. 2, someone who has permission to enter or use another's premises, but only for one's own purposes and not for the occupier's benefit. The occupier has a duty to warn the licensee of any dangerous conditions known to the occupier, but unknown to the licensee. An example of a licensee is a social guest. Invitee, a person who goes onto the land in furtherance of the owner's business. The owner has a greater duty of care towards an invitee than a licensee. The owner of care has a duty to exercise reasonable care in keeping the premises safe for use by the invitee, and the social guest, in contrast, is the licensee who enters the premises of the owner by permission, but for the licensee's own purposes. He goes onto the other person's property for companionship, diversion, or entertainment. A social guest must take the host's premises as he finds it. However, the owner has a duty to warn the licensee of a hidden danger which is unknown to the guest and which the owner has knowledge, and to refrain from injuring his guest willfully or wantonly. Saver. Invitees and licensees. Duties to persons entering owner's land. Licensees are owed a duty from the defendant to warn of dangerous conditions known to the owner. Invitees are owed by the defendant a duty to protect the entrant against unusual dangers of which the owner knew or should have known. And on public land, the city, state, or county owes to all persons coming on the premises a duty to use reasonable care to keep the premises safe. And for children, landowners have a higher duty of care to children. An attractive nuisance, that's the word that I was looking for, to refer to a lake, and that it is attractive to children, but it is a nuisance because it draws them onto the land to potentially hurt themselves. So landowners have a higher duty of care to children. From restatement section towards section 339, an attractive nuisance is artificial conditions, are now known as artificial conditions highly dangerous to trespassing children. And a possessor of land is liable to subject to liability for physical harm to children trespassing thereon caused by an artificial condition upon the land if A, B, C, D, and E. A, the place where the condition exists is one upon which the possessor knows or has reason to know that children are likely to trespass. So this is like where The condition is one of which the possessor knows or has reason to know, and which he realizes or should realize will involve an unreasonable risk of death or serious bodily injury, harm to such children. And C, the children, because of their youth, do not discover the condition or realize the risk involved in intermeddling with it or coming within an area made dangerous by it. So I don't know if you can provide adequate notice to a child. And D, the utility to the possessor of maintaining the condition and the burden of eliminating the danger are slight as compared with the risk of to the children involved. So I think we're talking about the risk utility balancing test. And E, lastly, the possessor fails to exercise reasonable care to eliminate the danger or otherwise protect the children. So first there has to just be an unreasonable danger that, isn't that expensive for him to mitigate. And he fails to mitigate it. Man is liable to the children's parent. Duties to lessor and lessee. A landlord owes a duty to exercise ordinary care in the maintenance of the premises. The landlord is under a duty of care to take reasonable precautions against such criminal acts. The elements of the duty drawn by analogy from other special relationships like innkeeper guests are from the Klein verse 1500 Massachusetts Ave Apartment Corporation, which I discussed in an earlier note. The landlord's ability to exercise control is higher, which is why public policy places the responsibility on him or burdens him with the cost of taking reasonable precautions against criminal acts of third parties. And the landlord's advantageous position in exercising control and minimizing risk, meaning that instead of having every single tenant in an apartment complex put a security camera outside their door, it's much easier for just the landlord to do it in front of the front door or maintain entrances such that they're limited to 1 to 3 doors instead of 10 from 4 cross streets. I don't know. And the knowledge of the landlord about, or key fobs to get in, and the knowledge of the landlord about the risk of the criminal behavior. If he has no idea the neighborhood has had 3 break-ins in the last month, that is a factor. Contributory and comparative negligence. We were discussing this in an earlier note. There's 4 legal effects from the plaintiff's negligent behavior. So, under pure contributory negligence, even 1% fault of the plaintiff bars the plaintiff's recovery entirely. And this is still followed in Virginia, Maryland, and DC. That's because people are especially stupid in that area. Just kidding. Places the cost onto 1 or 2 people at fault and undermines the goals of the tort system. Oh yeah, this is all according to California. And the last clear chance rule is one from the Davies case, that if the plaintiff can show that the negligent defendant had the last clear chance to avoid the accident, then the plaintiff's contributory negligence will save the plaintiff from being barred from recovery. So there's 2 cases that show this. The one that shows particularly this, the Davies case that we're referring to, is plaintiff ties his donkey's legs together so the donkey can't move. He's helpless. And the defendant comes by in a stagecoach and hits the donkey who's laying there on the ground helpless. And they say that it's the plaintiff's fault for leaving the donkey there where it shouldn't have been. And the plaintiff says, "No, you idiot, we're driving too fast, and you hit my donkey, and you had the last clear chance to avoid the injury, not me." And in that case, that constituted a rule. However, it works both ways. So if I, the landowner, defendant, I'm working on my house and I have like this huge long pipe, like PVC pipe or whatever, in the public highway, and then the plaintiff is riding his horse from the bar home, like in the dark, and is not intoxicated, but is going too fast, and is thrown from his horse and is hurt by his horse. He had the last clear chance to prevent injury by being more careful. And the defendant isn't necessarily liable at all under the pure contributory negligence theory for having pipe in the public highway at the time of the case. Pure comparative negligence from McIntyre, the jury will apportion the amounts of liability to each one of the parties. So, if the plaintiff who's thrown from his horse is only 10% to blame, then he gets the full recovery of 100% paid by the defendant, less 10%, which is attributable to the plaintiff's own fault. Modified comparative is the 51% rule, meaning that if the plaintiff is more at fault than the defendant, then the plaintiff can't get anything. So if the plaintiff is 90% at fault because he was maybe intoxicated when his horse struck the pipe at a high speed and threw him, then he's not going to get anything under the modified comparative negligence theory, but he would have gotten like 10% under the pure comparative negligence. And then there's this equipoise 50-50 rule that if both are negligent 50%, the case is barred. So this is just like, if you are just as at fault as the defendant, then you know what? Nobody gets nothing, apparently. Steps to analyze contributory negligence. Contributory negligence analysis. First, make sure that there is a negligent act. Then see if there is an affirmative defense to see if the defendant's liability is decreased because of contributory negligence by the plaintiff. Next, examine the conduct of the plaintiff to see if all 4 or 5 elements of negligence have been met. In other words, now do a negligence analysis as if the defendant was suing the plaintiff. If yes, look at the legal impact of the contributory negligence. And for assumption of the risk, this is another defense. It's kind of like synonymously held nowadays with contributory negligence, even though I can't explain it any further than that. There's 2 types of assumption of the risk. There's an express type and an implied type. Express means I signed a waiver. Implied means that I had another option. Like, so I had another bathroom that I could have used instead of the outhouse, but I went out to the outhouse and then I fell through the floor. I assume the risk of going to the outhouse instead of going in the house, and for that reason I would not be able to recover damages from falling through the floor. That was obviously damaged. The assumption of risk requirements. The plaintiff had actual knowledge of the risk, so it was obvious that the floor was broken. The plaintiff had an appreciation of the magnitude of the risk, meaning that I'm not blind to it, and or a child or crazy. and the plaintiff voluntarily encountered the risk, meaning that I had another option, and yet I chose to use the outhouse instead of the indoor option. Steps to analyze contributory negligence. Contributory negligence analysis, I think I already read this. Pre-injury release forms. Express assumption of the risk in Senghor versus the National Fitness Institute. Pre-injury release from liability. Plaintiff's assumption of the risk of injury through a pre-injury release from liability will be enforced if the injury is within the scope of the terms of the release and the release is not in violation of the public policy. So these pre-injury releases from liability are enforceable. However, I'm not going to be precluded from liability for a fire that occurs at my fitness center from the plaintiff who sustains injury from a fire that occurred, based on negligence. I would be precluded from liability if the injury resulted from the scope of the terms of the release, which would mean plaintiff using my equipment. And the release is not in violation of public policy. So you can't ask somebody to sign a pre-injury release if that party is like, let's just say, incapacitated or something, doesn't understand it. That's kind of unfair, and I don't think it would stand up in court. So, implied assumption of the risk found in Rush versus Commercial Realty Company. Wow, that's the exact one I was talking about with falling through the floor. Except in this case, it was not an implied assumption of risk because guess what? The outhouse was the only option that Rush had available. So in order for there to be implied assumption of the risk, the plaintiff's conduct must be voluntary. The plaintiff's actions are not voluntary if the plaintiff has no choice. So we've went over that. Assumptions of the risk requirements. This requires that the plaintiff had the actual knowledge of the risk, appreciated the magnitude of the risk, and voluntarily encountered the risk. The assumption of the risk analysis. Walk the case through the questions. Okay, I just discussed this stupid case. Statutes of limitation and repose. Yeah. Immunities. Vicarious liability, respondent superior, independent contractors, joint enterprise doctrine, strict liability, and the limitations thereof, products liability, strict liability, product defects, warning defects, manufacturing defects, design defects, and defenses. And then we get into nuisance, which we've sort of went over, as well as defamation, which we kind of went over that whole section, how it relates to private plaintiffs, public officials, the condition of it being false, and privileges for defamation. Products liability has a whole read-through. Self-defense, I have a whole read-through. Defamation, libel, slander, and defenses lecture, a whole read-through that. Joint enterprise doctrine and contributory negligence and assumption of the risk. So these are all going to come to you in a concepts recording.